You are now tuned into the Black Law Students Association of Canada's YouTube.
Thank you for your attention, and without further ado, I will now cede the floor to our Honorable Justices of the Diversity High Court of Canada, Justice Daniel Dortelis and Justice Valerie Bailey. Thank you.
Good evening, everyone. Bonsoir tout le monde. Il me semble qu'on manque l'un des juges. Alors, on ne peut pas commencer jusqu'à temps où il... It looks like we're missing one of the judges. I think he was previously present, but there might have been a technical issue. Does anyone know how to...
I can ask for technical help.
Yeah, if you could do that, that would be great.
Okay, so yes, I've invited the host. In the meantime, I will pause the recording.
Monsieur le juge, est-ce que vous pouvez nous entendre?
Oui, je vous entends. Je pense que je me suis perdu. Je suis rendu dans... Je ne suis pas à la bonne place. Est-ce que je suis à la bonne place?
Oui, maintenant.
Oui?
Oui.
OK, dans le room 4.
Oui, oui,
OK.
c'est ça.
Parce que j'ai fait quelques clics, je pense que je m'étais perdu de chambre.
Oui, donc
Très
maintenant...
bien. Donc, je suis à la bonne place.
Oui, oui.
Très bien. Merci.
Alors, je pense qu'on peut commencer. Donc, je vais demander à l'appelant, je ne sais pas exactement comment ça fonctionne, mais on peut commencer maintenant, je pense.
Hello, can you hear me well?
Yes, we can hear you.
Okay, perfect. My name is Tarek Shawan. I'm here with my co-counsel, Olivia Ma. We're here on behalf of the appellant, and we will speak 17 minutes each. The issue we're pleading today is whether Canada's failure to collect disaggregated race-based data pertaining to COVID-19 infringes the right to life security of the person under Section 7 of the Charter and equality rights under Section 15, and whether the interpretation of the Constitution put forward by the Supreme Court majority decision by excluding positive obligations from Section 7 and Section 15 of the Charter will perpetuate embedded systems of racism and inequity in the Canadian society, which will ultimately contribute to the deprivation of life, security, and equality for racial minorities. Today, in our arguments, we will do the following. First, we will highlight the most important facts relating to the issues at hand. Second, we will show how the minister's decision of rejecting collecting disaggregated race-based data engages the right to life and security of Mr. William, our appellant, and Section 15 in a non-trivial way on a balance of probabilities, and that this deprivation is not in accordance with principles of fundamental justice, and that is not saved by Section 1 analysis. Third thing, our analysis will empirically interrogate the relationship between data collection, race, and the pernicious effects of COVID-19 on racial minorities. And fourth of all, we will talk about the problematic nature of the false dichotomy between negative and positive obligations and its relationship to critical race theory. First, I will start with the facts. Data saves lives. Data collection helps public authorities to grasp the urgency of better protecting vulnerable individuals at the risk of harm and measuring how efficient the policies are to redress these issues. The collection of age-based data identified for the Canadian government that the majority of people who die from COVID-19 are people who are above a certain age, and therefore it helped the Canadian government to prioritize older populations in terms of vaccines and social distancing, thus saving lives. We all know that the infection rates within racialized communities are alarming. This overrepresentation of minorities in terms of mortality and infection rates for COVID-19 is due to the fact that these minorities are overrepresented in high-risk jobs, such as essential workers and frontline workers. Even though the collection of race-based data could have negative effects, such as stigmatization, increased police surveillance, and other effects that those effects are substantively outweighed by the beneficial effects of collecting data, such as saving lives, reduction of infection rates, and the attenuation of the pernicious effects of structures of racism. The father of critical race theory, Derek Bell, says that critical race theory is concerned with exposing, disrupting, challenging, and changing racist policies that work to subordinate and disenfranchise people of color. But how can we expose those policies without evidence of the extent of harm that these policies create? So evidence is only possible with data. Finally, in terms of fact, critical race theorists such as Ladson, Billings, and Tate argues that the problem in our society is that race as a topic is under-theorized and understudied. Critical race theorists begin with the premise that race matters and should be studied and conceptualized in making sense of our reality. It's true that race is unreal from a scientific category, but its mode of existence are real and have innumerable materials and social consequences. Now that I finished from the facts, I will move to analyze Section 7. According to Carter, the purpose of Section 7 is a profound respect for the value of human life. Our analysis will look into two-pronged tests: the failure to collect race-based data, whether it limits the claimant, our appellant, right to life and security, and if so, whether this deprivation or interference is in accordance with principles of fundamental justice. Let's look at the constitutional history. In the case of Carter, the right to life was engaged or is engaged when there's a threat to death as a result of government actions or laws. Further, it was suggested that the right to life is engaged when the law or state action imposes death or increased risk of death on people, either directly or indirectly. And we put two lines under indirectly. This is in paragraph 62. So we ask ourselves, does the prohibition of data collection increase the risk of death, directly or indirectly? As we said before, it's impossible from an epistemological point of view. You cannot know the extent of damage until you measure the cause or phenomena. This has been emphasized by famous author James Harrington, who said that, and he was also an engineer, who said that the first step towards control, that measurement is the first step towards control, and control is the precedent towards improvement. So if we have no data, it means we don't have a measurement, we have no control, and no improvement. Within the context of right to life, the Canadian government has already used the tools of data collection to measure the harm and to reduce it to people in terms of their life emanating from certain emergent issues. For example, the race-based data collected by Cancer Care Ontario shed the light on the lack of cancer screening for Black women, which the provincial government of Ontario enacted certain programs to increase this cancer screening for Black women and therefore saved more lives. Indeed, the emergence of the gun registry database as a result of the 1995 Firearms Act and the recent Statistics Canada decision to collect data about the origins of guns helped reduce death. And this was confirmed by an RCMP study in 2010, which concluded that the registry has saved lives and reduced firearms-related harms, almost a 12% decrease in firearms deaths between 2001 and 2004. But the question that might be asked here, where does race fit within the correlation of data between data collection and increased risk of death? Let's talk a little bit about COVID-19 and race. Empirical data confirms that pandemics and diseases affects racial minorities in North America much more than white Canadians. So data from H1N1 influenza pandemic demonstrated that shockingly, Black community in Ontario were 10 times more likely to contract H1N1 influenza than white Canadians. The same thing is applied in the context of COVID-19 in Montreal and in Toronto, where the data shows that neighborhoods with higher rates of people from racialized minorities have double and triple infection rates compared to neighborhoods with lower rates of racial minorities. So to make sense of this data, we use the aid of a critical race theory again that explain the statistical correlation, because poverty, unemployment, lack of income make racial minorities live in multi-generational households, and therefore they cannot have social distancing. It forces them to stay home because they cannot afford childcare. So we see some kind of a inter-institutional structural arrangements that produces a cumulative outcome that exposes racial minorities. And I'm using the words here of John Calmore, a CRT theorist. So the current data about race, to understand the concept of race here, we need a data about the inter-institutions. We need data about housing, employment, and therefore only the federal government could have access to this data. To continue on the right to life, so if we decide not to collect data, this feeds into the issue raised by critical race theorists of the under-theorization of the issue of race, which lead to colorblind policies. Color blindness minimizing the recognition that racism is a determinant of health, and which is empirically proven. The deprivation of data also imposes dangerous conditions on racialized minorities, which in itself increase the rate of death. So we have a chain of causation that we have to follow here. I'm gonna move right now to the right of security, and because I talked before about the right to life. Security of the person is very important. It's a basic entitlement guaranteed by Universal Declaration of Human Rights, Article 3. The case of Rodriguez, the majority decision, considered the psychological and the physical well-being of people as interests protected by the right to security. And the deprivation here ought to be non-trivial using an objective test. I would like to highlight Justice Abella's dissent in the case of Gosselin, where she linked the right of security to the right to have minimal social assistance. And she says that the lack of the latter caused hardships and marginalizations due to poverty, which induces individuals to suffer from isolation, PTSDs, anxieties, stresses. So let's see if that applies. Let's talk about the facts. Black Canadians are overrepresented in feminized gig economy jobs, exposing themselves ever greatly to COVID-19. For example, 63% of the precarious jobs in Toronto are occupied by racial minorities, and racial minorities are only 46% of the workforce in Toronto. Those people are unable to work remotely. That increases their exposure. And the fact that they have to maintain hygiene, social distancing, they have to avoid and disperse crowds, is connected to mental health issues and was proven empirically by a study by Sonia Kabarka in 2020. So the increased level of infections and mental health issues reduces racial minorities' income, further exacerbates issues related to housing, that exacerbates food security, which increases drug addictions. Those are the same pernicious effects that Justice Abella talked about in the case of Gosselin, which was connected to the reduction of social assistance, which engaged the right of security. I will move right now to the principles of fundamental justice.
Counsel, I'm wondering if you can just be a little bit more specific with the connection between the deprivation of the right to security and data collection itself. Because if we accept some of what you've just said, is it the lack of data collection that's the problem, or is it other state actions or state failures to act that are the problem in terms of the right to security?
Yeah, so the chain of causation that we see here, which was empirically proven, is that when we do not have data, there's no government, there will be no measurement of the extent of harm in terms of psychological harm, in terms of mental and physical well-being of racialized minorities. And once we do not have data, it's impossible for us to create policies to redress this inequality, and therefore we are indirectly placing racialized minorities in a dangerous environment. So I will come back to the principles of fundamental justice. We submit today that this deprivation to life security is not in accordance with principles of fundamental justice, which is the second test of Section 7. Drawing on the case of Malmo Lavin, gross disproportionality describes state actions to an issue that is so extreme as to be disproportionate to any legitimate government interest. So the grossly disproportionate decisions achieves the government purposes, but does it as a prohibitive cost to life, liberty, and security. The goal of the minister, by rejecting or refusing to collect disaggregated race-based data, because he wanted to abort a potential social stigmatization or increased police surveillance, which is speculative at best. But he may achieve this goal, but he achieved it with high cost to lives, because we cannot think of any government interest that can justify the loss of thousands of lives of Canadians, lives that could have been spared had the minister decided to measure, understand, and then remedy the impact of COVID-19 on racial minorities, just like the gun registry did with the victims of gun violence. I will let my co-counsel Olivia to speak about Section 15 analysis and Section 1 and other CRT arguments.
Thank you to my co-counsel Tarek for explaining the violation of Mr. Williams' Section 7 right to life, liberty, and security. I'll be arguing the second doctrinal issue, which pertains to the violation of Mr. Williams' Section 15(1) rights to equality. The minister's legislative decision for not collecting disaggregated race-based data on COVID-19 violates Mr. Williams' right to equality because it exacerbates the consequences of COVID-19 on Indigenous and racialized communities. The conceptual foundation, which underlies subsection 15.1 is the promotion of substantive equality. It takes into account the realities of inequities within our society, and it ensures equality of outcomes. This is well established in the two-pronged test that was first articulated in the Andrews case. Substantive equality is also at the core of the protection against adverse discrimination, which recognizes that neutral policies on their faces may result in disproportionate impact, disadvantaging some communities, which is the case that we have today. In other words, Mr. Williams' claim isn't that the state action explicitly causes a disproportionate impact of COVID-19 on racialized communities. Rather, he's arguing that the lack thereof places racialized minorities at a disadvantage. So to determine whether the minister's action is actually adversely discriminatory against the protected group, we will be arguing, following the two-pronged test first set out by Andrews, that first, the law creates a distinction based on the enumerated ground of race, and second, that the distinction does create a disadvantage by perpetuating prejudice and stereotyping. So I'll begin with the first branch. The first branch requires evidence of a disproportionate impact on members of a protected group. The protected group in this claim is that the discrimination falls under the enumerated ground of race. So to prove disproportionate impact, we have to demonstrate a desperate pattern of exclusion or of harm that is statistically significant and doesn't simply result of chance. So in the case of Frazier, the court identified two forms of evidence which are useful to prove a disproportionate impact. The first is evidence about the situation on the claimant group, and the second is evidence about the result of the law itself. In my co-counsel's arguments of Section 7, he evidenced a number of empirical data at the intersection of healthcare and marginalized communities. Without repeating what my co-counsel has already stated, these include evidence that members of racialized communities are significantly more affected by COVID-19 and by other health crises around the world and within our Canadian society. This data be a strong indication of disproportionate effect of COVID-19 within our society in Canada and should not be dismissed as a fluke or as a result of chance. The second type of relevant evidence pertains to the effect of the law. So the lack of race-based data prevents any form of implementation of informed policies and renders any form of accommodation for the members of a protected group impossible. In the case of Eldridge, the lack of accommodation was a result of no sign language interpreters in healthcare schemes in the hospital setting. Just like this case, it was a neutral policy on its face, which disproportionately affected those with hearing disabilities. In this case, in our present case, the lack of disaggregated data parallels the lack of sign language interpreters in the case of Eldridge. The scope of the effect of the state action cannot simply be limited at the absence of empirical data. It has to be broadened to include the result of not accessing this information, without which makes it impossible to adequately accommodate the communities by addressing the problems that they are facing. So these evidence clearly show a disproportionate impact on racialized communities. I'll be moving on to the second branch of the test, which asks whether the distinction has the effect of reinforcing, of perpetuating, or exacerbating a disadvantage. So the impact of the harm caused by the protected group has to be viewed in light of historical and of systemic advantages faced by the claimant group. Racism creates health disparities through 4 pathways that we've identified. First being economic and social deprivations. Second is harmful environments caused by residential segregation. Third being inadequate or degrading medical health care, which result from implicit biases. And then the fourth is elevated risk to social stressors. So the first pathway to health disparities is socioeconomic status. A higher socioeconomic status in most countries and throughout most conditions lead to higher health outcomes. But we can't simply mechanically shift the narrative away from race towards socioeconomic status. We have to acknowledge that the current systems of discrimination and of racism, for example, in education, employment, and in housing schemes, lead to unequal resources to health and increase the difficulty for members of racialized communities to reach higher socioeconomic status and to access better healthcare. Second, one manifestation of the historical effects of racial residential segregation is the differences in neighborhood quality and in living conditions, which include access to medical care. This form of segregation leads to racialized communities being disproportionately exposed to pollution as they're relegated to dilapidated environments. These communities are deprioritized when decision makers enact policies. For example, the poison lead water crisis in Flint, Michigan disproportionately affects Black people. The third pathway to health disparities is implicit biases. In the US, statistical evidence demonstrates that even in comparable healthcare access, which include insurance status, income, age, and severity of medical conditions, members of racialized communities receive poor quality of healthcare services compared to their white counterparts. This difference is explained by the implicit biases of healthcare professionals. Just like the general public, these healthcare professionals are subject to negative narratives about racialized communities. These discourses subconsciously are included in their medical services. Fourth is that racialized communities are subject to more pernicious mental health consequences. Data is clear in demonstrating that racialized communities racialized communities are disproportionately impacted because with regards to mental health because of higher socioeconomic disadvantages and institutionalized discrimination. This elevates their exposure to hardship, to conflict, crime, financial strain, and unemployment, just to name a few adversities they face. The increased harm on mental health because of this higher exposure to adversity has to be accounted for in the broader conversation about COVID-19 and its effect on mental health. So despite the categorization, these considerations contribute to a broader picture of the exclusionary medical disadvantage, which is experienced by members of Indigenous and of racialized communities on both an interpersonal as well as a systemic basis. Not only should racialized communities be protected against these risks, the disadvantages they experience also are exacerbated by COVID-19. So now I'll be moving on to a Section 1 analysis. We argue that the violation of right to life, to liberty, and to security under Section 7, as well as the violation to the right of equality under Section 15 cannot be justified in a free and democratic society. Section 1 of the Charter puts the burden on the minister to justify the breach through a pressing and through a substantive objective. There's no explicit pressing and substantive objective to the minister's decision to not collect race-based data, but we've identified two purposes which motivate the collection of general disaggregated data, for example, age-based or gender-based data. First is that data collection serves to better understand, to better track, and to better control the spread of the coronavirus. That leads to our second purpose, which is the protection of the Canadian population and the possibility for the minister to create informed healthcare policies. It's persuasive to underline that the objective of the Canadian healthcare policy is to protect, to promote, and to restore the physical and mental well-being of Canadians, and to facilitate access to healthcare services without barriers. So first, the objective behind the minister's decision is not rationally connected to its effects. In the case of Fraser, the court determined that the legislative limitation on job shares being granted full-time pension credit for their services was not only unjustified, but it was actually contrary to the legislative purpose, which was to improve the position of female RCMP members who decide to take leave to care for their children. Similarly, in our case, the minister's action to not collect race-based data is also contrary to the purpose of protecting Canadian health and to provide unbarred access to healthcare. In order to provide adequate healthcare, it's necessary to understand the precise problems that are faced by the people seeking this healthcare. Without empirical data, it's impossible to understand how the virus manifests in marginalized communities. Not only does it render the enactment of targeted and informed healthcare policies completely impossible, it also creates a greater spread of the virus, and it amplifies the risks to the broader Canadian community. The second branch of the Oakes test, the minimal impairment stage, asks whether the limit on the right is reasonably tailored to the objective. As I've discussed in the rational connection analysis, the decision to not collect this data is actually contrary rather than in line with the purposes. So discussion on minimal impairment is obsolete because the impairment of the right doesn't actually further the minister's objectives. The third and final stage of the Oakes test weighs the impact of the law on the protected rights against the beneficial effect of the law in terms of the general public. In the judgment on appeal, Justice Brown was concerned with the use of the collected data in ways that would undermine racial justice in terms of surveillance as well as systemic discrimination. These concerns are very valid, and collected medical data must be used or must be protected against all forms of unconstitutional and unjust use by not only the state, but private parties as well. We argue, however, that the deleterious effects which result from the impossibility of enacting informed policies actually outweigh the salutary effects of not risking this abuse of data. First, as we know, we are facing the greatest biomedical threat in history, which this week has already taken over the lives of over 20,000 Canadians. Controlling the spread and providing medical aid to those affected by COVID-19 must be at the forefront of the government's priorities. And second, to minimize all forms of racial essentialism, administering the collection of race-based data would include participation from racialized communities. So to conclude the Section 1 analysis, we argue that the violation of Section 7 rights to life, liberty, and security, as well as the violation of the Section 15 rights to equality cannot be justified in a free and democratic society. Now I'll be giving the floor to Tarek to discuss our doctrinal argument, which criticizes and deconstructs the positive-negative obligation distinction.
Thank you, Olivia. The majority decision at the Supreme Court refused to say that the minister ought to collect race-based data because it amounts to the imposition of positive rights upon the minister. But we believe that this decision does not reflect the current movement in case law and the current movement in constitutional doctrines. We see, for example, in the UK, that the UK law imposes positive obligations to the right to life. For example, the Human Rights Act, Article 2, imposes positive obligation on the state to protect life. We see something similar in Canada. The Supreme Court, in the case of Gosselin, left open the question of whether positive right could be imposed to a minimum level of healthcare that exists under Section 7. This is, I'm referring to paragraph 81 to 83. But today, we're going to push the argument a little further because of the importance of the critical race theory. We claim that we submit today that we ought to deconstruct this false dichotomy between positive and negative rights. For example, we draw on constitutional case law. For example, when we look at case law regarding Section 7 and Section 15, we saw that courts have been dealing with issues relating to substantive policy, issues that have substantive policy implications while using negative rights. For example, the case of Morgenthaler, the courts adjudicated on the issue of abortion. In Rodriguez and Carter, the court adjudicated in the issue of assisted suicide or assisted mate. In the case of Gosselin, we see the issue of state-funded social assistance. And in Shaoli, the court decided on the issue of access to healthcare or delay to access to healthcare. This means that when the courts are conducting a judicial review on state action and discretion, the false dichotomy or the dichotomy between positive and negative rights has no bearing on the institutional legitimacy of the court and the division of powers within the state. This is precisely why Justice Arbour, in the case of Gosselin, in paragraph 344, advocated for a purposive analysis of Section 7, so we can give the right to life some meaning. So regarding of having positive and negative rights, we see some substantive policy cases, or we can call it political cases, that can be easily translated into law or state action. And we submit that those laws and state actions should not escape the scrutiny of the Charter. We also argue that both the negative and positive rights or obligations require remedial options from the legislative branch, and therefore they're both intrusive on the legislative decision-making. The only possible difference that we can see between positive and negative rights is that it's possible that positive rights require more direct remedial options than negative rights, but the end result is the same. For example, when we talk about the issue of assisted MAID or assisted suicide or assisted dying in the case of Carter, the majority case used negative rights language, but after the case, we saw that the legislative branch enacted Bill C-14, which required budgets, of course, but also which had to create a scheme for doctors and other stakeholders to conduct assisted dying. So to conclude, one may ask from a legitimate question about the difference. Sorry, one may ask a legitimate question from the difference between the standpoint of the rights holder between states restricting access to certain social services like healthcare and states' failure to provide it. We see that negative obligations always have positive implications that are inescapable and therefore creates a bearing on the legislative or impact on the legislative branch to impose positive obligations. My co-counsel Olivia will continue on the critical race theory and the living tree constitutional arguments.
Thank you. Thank you to my co-counsel Tarek. So the living tree doctrine is the solution to escape this legal conundrum. The Charter, as the living tree, must grow to fit the emergent realities of today's society and can't stunt the possibility of growth and of development. As my co-counsel explained, the unwillingness to impose positive obligations on the state limits the breadth of legislative decisions that can be taken to ameliorate our society. So it's crucial to scrutinize our current rigid interpretation of the Charter rights and reinterpret them in a progressive way. It's clear that social marginalization leads to suboptimal healthcare experienced by racialized minorities, and that's always been our reality. Today's state of the world, being COVID-19, not only is a painful reminder of the pre-existing health inequities, but also exacerbates health discrepancies. As a remedy, we have to shift the paradigm of community health to target the root issue. Racism is what drives racial marginalization and leads to these health inequities. Racism affects policymaking in turn translates into law, and then these laws should not escape the scrutiny of the Charter. But it's impossible to breathe life into this new paradigm of community health while still holding on to the interpretation of Section 7 and of Section 15 that limit the imposition of positive obligations on the state. This conception of the Charter fails to remedy the current structures of racism. Many critical race theorists advocate for this form of change. Mary Matsuda, for one, argues that the law must target the subtle forms of discrimination that the law itself is perpetuating. First, by deconstructing these forms of discrimination, then by reconstructing them by looking at the harm on Black communities that result from the effect of these new rights. In these new lens, newly reconstructed rights emerge from deconstructing the positive-negative obligation dichotomy. These newly reconstructed rights also act as the engine that empowers racialized minorities to challenge the structures of racism and of subtle discrimination embedded in our legal system. In our case, the emergence of race-based database for COVID-19 should be designed in collaboration with racial minorities to integrate their perceptions and their fears during the design and the implementation phases of these databases. This is instrumental in guarding against the remedies that can be used to perpetuate subtle forms of discrimination and of racism in Canada, while also ensuring the neutrality of this data. So the case we brought forth today is more than simply about the lack of collecting race-based data. This case comes to us as a concrete example of the failures of our government to meet the needs of vulnerable people in the Canadian society. This case also presents itself as an opportunity, in the words of Justice Brown, to demonstrate exceptional judicial response and remedy these harms. This court, the High Diversity Court, is the institutional body best positioned to address these systemic imbalances and reduce harm, as well as save lives. So to conclude, the appellants submit that the minister's decision to not collect disaggregated race-based data with respect to COVID-19 first violates Mr. Williams' Section 7 rights to life, liberty, and security, as well as his Section 15 rights to equality, and that these violations cannot be justified in a free and democratic society. We also submit—
Counsel, I have a question.
Yes.
Just to drill down a little bit more on your argument about positive and negative rights, is your position that we should, that our law should accommodate not only the protection of negative rights, but also the imposition of positive obligations? Or is it that we should remove that distinction entirely and no longer view it as positive rights and negative rights?
So we submit that this distinction in terms of its effects on the legislative body of our government is fictional, regardless of if it's imposing a positive obligation or a negative obligation on the state. The effect of it is the same. So from a legal standpoint, we argued that this distinction should just completely be removed and should not be a barrier to bring up claims such as ours today. So just to conclude, we also submit that on the same topic, that to target the issue of health disparities at its root, the Charter has to grow as a living tree to deconstruct this legal fiction of positive negative obligations. And for these reasons put forth today, the appellants request that this honorable court accept this appeal, reinstate the judgment of the Ontario Court of Appeal. And so subject to any further discussions, these are our submissions. Thank you very much.
Thank you.
Thank you very much.
Thank you.
Can we go now?
I have no question.
I also have no further questions.
The presentation was quite clear, and your argumentation was quite convincing.
Thank you very much.
Thank you so much.
I agree.
And you have managed to make the presentation within the time allowed.
So now I think we go to the respondent, Naitimi.
I believe so.
Yes. Can you hear me well? Right. Greetings to the court, Justice Dortelis and Justice Bailey. I am Monica Madungu and my co-counsel is Harleen Kaloti. In regard to this matter, we represent the counsel of the respondent, and on the behalf of our client, the Minister of Health, we respectfully request this motion to be dismissed. Until this appeal, the appellant alleged that our client did fail to collect disaggregated race database. So he's claiming that this infringed his right to life, security, and liberty under Section 7 and his right to equality under Section 15 of the Charter. Our position about this is clear. Our client didn't violate those two sections. Let me introduce you first to our first argument, which is a non-violation of the right to life, liberty, and security of the person protected by Section 7. It is in Sharkari versus Canada that the court discussed about the purpose of Section 7, which is to enable the government to do an action which conducts to the deprivation of life, liberty, or security of a person as long as it is conforming to the principle of fundamental justice. The court also added in the same case that Section 7 only guarantees individual rights and not rights for groups of people or for collectivity. And he also recognized that it is possible to invoke Section 7 by applying two-steps analysis. So firstly, the applicant in our case, which is the appellant, must prove that there's an infringement of his right to life or his right to liberty or his right to security, so he can plead for deprivation. And secondly, the applicant must prove also that the deprivation is not conforming to the principles of fundamental justice. Let's move now to the analysis of these two rights. About the right to life, in Carter case, the court said that Section 7 is engaged where the law or state action impose or increase risk of death. So Section 7 do not impose any obligation to government to ensure life, because the court, in the same case, also recognized that it is possible to renounce to this right. My question here is, it is right to say that a failure to collect data increase or impose death? Obviously, the answer is no. No doubt, COVID-19 kills a lot of people. But my concern is that thus far, there is no scientific correlation between those casualties and the color of the victim's skin or the collection of data. In clearest words, as long as a person is affected by the virus, no matter the color of its skin or the race he/her belongs to, that person becomes susceptible to die because of the bad consequences of that virus. Therefore, not collecting disaggregated database on COVID-19 for Black community won't expose them more to the virus. Data are not the protection against the death caused by the virus. The vaccine is the protection, not data. There are no more questions on it. Whether we are Black, white, indigenous, aged, or young, we are exposed to the various fatalities. So the omission of a client to not collect this data cannot be related to a risk of an imposition of death or an increasing of death. Therefore, there is no infringement to the right of life of the appellant to us. Now about the right to liberty. And this right has two aspects. The first one is directed to the protection of a person in the physical sense. We talk here about the physical restraint. And in the Queen versus Vaillancourt case, and the court gave an example of physical restraint as imprisonment or threat of imprisonment. The second aspect is the protection of personal autonomy. Here we talk about the capacity to make fundamental choice about our own life. In Gobu versus Longueuil, the court recognized that the capacity to decide where we want to live is one of the protection of personal autonomy. So applying this understanding of right to liberty to our case, it is impossible to draw a conclusion that the omission of a client affects the physical sense or personal autonomy of the appellant. He didn't even show a proof of it. But the real proof is that we did not receive any legal letter coming from a doctor or psychologist confirming that the appellant had huge damage because of the non-collection of data. There's no confirmation by a psychologist or doctor that the appellant has lost the control of his personal autonomy. He could lawsuit us here, so we can suppose that he is still in control. Well, this court, this honorable court, must make it clear. Requesting the minister to collect data is not one of the protections of the right to liberty. Then, about the right to security, discussed in Rodriguez versus Canada case, it is true that the court usually gives to this right a broad interpretation because of its physical and psychological aspects. Right to security does include right to control our own bodily integrity. And this right can be engaged in the following situation. First, if the state action have interfered with personal autonomy or ability of a person to control his or her own psychological integrity, yeah, we can engage the right. And that is why in Rodriguez versus, in Rodriguez case, the court recognized that prohibition of assisted suicide engage right to security under Section 7. We can also engage this section when the state action seriously affects mental health is a cause of serious psychological harm. So it is true that our client refrained to collect data, but it is causing a real impairment to the physical or psychological integrity of the appellant. Again, for us, the answer is no. If the body of the appellant is affected by COVID-19, it is not because data has not been collected. COVID-19 is affecting every race, and it does not distinguish the color of the skin of people. So if the body of someone is harmed because that person contracts COVID-19, it is only because of COVID-19. It is only because of the effects of the virus and not because we do not have data on it.
Counsel?
So, yeah.
I have a question. What do you say to the appellant's argument that the failure to collect data can result in the government failing to take other actions that would protect the lives of people who are affected with COVID and communities who might be more affected by COVID than others?
What I do answer to this? Well, I want to make it clear. We are not here to talk about the benefits of collecting data. Collecting data is good, but we are here to talk about, does our client has that obligation coming from the charter to collect them? And to us, the answer is no. Perhaps collecting data will be good for the research, will be good for having more data on the COVID-19 and communities, but we are not here to talk about the benefits. We are here to talk about what the law says. And to us, the law, the charter is not giving that obligation to our minds, to our client. So this is my answer.
Thank you.
Pleasure. And to continue, given all the above, there is no infringement of the Section 7. So I won't go further to the principles of fundamental justice, because to us there is no infringement of the Section 7. I'll skip to our next argument, which is this non-violation of Section 15 of the Charter. So Section 15 sets the right to equality. In the Queen versus Cap case, the court says that right to equality means that everyone deserves to receive the same treatment under law. We talk about the same concern, the same respect, the same consideration. And it forbids the state to take measures, adopt legislations or regulations which promote discrimination against a group. So to establish a violation of Section 15, the state must have initiated a discriminative action based on prohibited, enumerated, or analogous grounds. Enumerated grounds are in the wording of the section, so ethnic origin, race, age, color, sex, religion. And the analogous grounds are not that much different from the enumerated grounds, except that the analogous grounds identify stereotypical decision for individuals or historic discriminated group. And in Andrew versus Law case, versus Law Society of British Columbia, the court has held some new analogous grounds, but this is not the concern about our case. So about to determine the violation of Section 7, we must answer to the following questions. There are three. First one is whether a law impose differential treatment between the claimant and others in purpose or effect. The second question is whether one or more enumerated or analogous grounds of discrimination are the basis of the differential treatment. And the third question we must answer to is whether the law in question has a purpose or effect that is discriminatory within the meaning of the equality guarantee. To answer to the first question, so if there is a law imposing differential treatment between the claimants, so in our case, the appellant and others, the answer for us is simply no, because the decision of our client is not a law, is not a legislation, is not a regulation, it is simply an omission. So we cannot associate an omission to the basis of a law. So for us, there is no law, so there is no differential treatment. And about the second question, the answer is also no. There's no law giving a discrimination on the basis of enumerated or analogous grounds. It is true that the appellant here belongs to Black community. So yes, we will say that one enumerated ground can be raised, but the omission of a client is not only for Black community, it is for everyone. So we cannot plead for a differential treatment because no disaggregated data has been collected for other community too. So this court must recognize that there's no differential treatment between the appellant and his community and other community. And then whether the law in question has a purpose or effect that is discriminatory, again, the answer is simply no. So as I establish it, there's no violation of Section 15. So we don't need to go further about Section 1 because Section 1 is only involved when there is a violation of Section 15. To conclude, perhaps, as I said before, collecting data will help to have better information on communities and communities facing COVID-19. But again, this is not the concerning of this case. the benefits of collecting data is not the issue on this case. On this case, the issue is to determine if our client did violate the charter. And if he did so, that will mean that the charter does give an obligation to a client to collect those data. But for us, under the charter, there is no obligation for our client to collect disaggregated race database. So our client didn't violate the right to life, security, and liberty under Section 7 and the right to equality under Section 50 of the Appellant. Thank you. Now I give the word to my co-counsel, Harleen Calotti.
Thank you, Monica. Greetings to the member of the court. For my part, I will tackle the theoretical argument. So it is obvious that collecting disaggregated race data will violate the protection of privacy. Why? Well, because the data will not exclusively remain in the hands of the health minister. In fact, the data will be diffused by the Minister of Health because it is public information, which means private corporations can utilize the data however they want. So for example, private companies such as polarized newspapers with malicious intent can use that data to create stigmatization, marginalization, or discrimination towards a certain community. As mentioned in the 5th paragraph of the Supreme Court Canada's decision, William versus Canada, revealing privacy elements of the life of a specific group is directly linked to expose them to public discrimination. I'll actually quote a part of it. Perhaps confirmation that more Black people have been impacted by the COVID-19 pandemic will increase racial prejudice against those people, who some will wrongly assume are the authors of their own misfortune. And perhaps the collection of race-based data will be liable to the risk that such data will be used by public and private interests in a way that ultimately undermine racial justice in terms of surveillance and systemic discrimination. So there are two main privacy laws in Canada. The first one is the Privacy Act, and the second one is the Personal Information Protection and Electronic Documents Act. So in order to understand this document, it is very crucial to understand the definition of what is personal information. So according to the Office of the Privacy Commissioner of Canada, personal information allows the identification of a person. It is data that can classify you as a person by itself or in conjunction with other pieces of information. So under both of the acts that I just mentioned previously, the concept of personal information varies slightly, but in both cases, it does include the following information. So the ethnic origin, the religion, the age, the marital status, medical history, financial information, DNA, and views or opinion. So the Privacy Act provides protection of personal information, describing it as any registered data about an identifiable person, whereas the Personal Information Protection and Electronic Documents Act provides the rules surrounding the acquisition and usage of personal information by private sector entities and federal regulated businesses in the context of corporate practices across Canada. In this current case, the collect of disaggregated race data does fall under the definition of personal information, according to the definition I provided by both of the acts that I just mentioned previously. Now I'll be talking about how the collection of such data can cause stigmatization. So the collection of disaggregated race data can lead to stigmatization and increased discrimination towards certain communities. I will give some examples from the past that led to severe stigmatization of a community. It is important to note that this type of discrimination can cause a lot of mental distress or generate any other mental repercussion among the stigmatized communities. So my first example is from the 1980s. So it is basically the stigma faced by the Haitian community of Montreal that was caused by HEMA Quebec. So just to put it into context, thousands of Canadians were afflicted with HIV and hepatitis C in the early 1980s. The Haitian community was essentially blamed for bringing AIDS to Quebec. So, to avoid this contamination of blood products, Canadian health authorities urged Haitians to actively refrain themselves from giving blood, among other communities. The Haitian community then tried to negotiate with the Department of Health to exclude themselves from the self-exclusion list in the months following the release of that declaration, but unfortunately, they did not agree. So, what are the consequences of such declaration? Well, the Haitian community of Montreal did face a lot of social stigma caused by Quebec's discrimination because they were refraining them from donating blood. We can anticipate similar consequences and results if we allow a health minister to collect desegregated race data. So my second example is from the initial COVID-19 outbreak in the Jewish community of Montreal, which was only a couple months back. So it is a very recent example. According to Global News, the police received a call regarding a Outremont synagogue probing a religious ritual despite having limits on gathering due to the first coronavirus outbreak in Montreal. That Jewish community was then put under quarantine after multiple members tested positive for COVID-19. According to that Jewish community of Montreal, certain errors were definitely made on their side, but the degree of focus on the Jewish community was way out of proportion. The Jewish community also stated that people were unfairly laying blames for the spread of the coronavirus on the Montreal's Jewish community. So again, this situation led to social stigma of the Montreal Hasidic Jewish community. Not only that they faced severe stigmatization, but they unfortunately faced a lot of discrimination also. To put it into perspective for the current case, if the Minister of Health collects such desegregated race data and consequently enters into Black people's privacy, it will then exacerbate racial prejudice. In other words, this can create additional and unwanted marginalization and stigma. So my third example is the racism against people of Asian descent during the first coronavirus outbreak, which also only happened a couple months back. So again, this is a very recent example of discrimination. So there's actually a report studying racism against people of Asian descent related to the coronavirus outbreak pandemic in Quebec. So in that report, the author studied hate-motivated crimes during the initial coronavirus outbreak against people of Asian descent in Quebec. In other words, the study shows the discrimination faced by people of Asian descent with concrete examples of in-store intimidation, racial taunts, and violent attacks. According to CTV News, a woman intentionally coughed in an Asian person's face, a Korean man got stabbed, and there were a series of taunts for Asian people to go back to their country because they were blamed essentially for the ongoing health crisis. So these are all concrete examples of horror situations faced by people of Asian descent on daily basis during the initial coronavirus outbreak. It is clear that the media had a major role to play in fueling anti-Asian racism during the first coronavirus outbreak. This increased discrimination towards people of Asian descent impacted severely their well-being. This is another example of available data leading sadly to stigmatization and discrimination of a certain community.
Counsel,
yeah.
What do you say to the appellant's argument that it would be possible to collect data in a way that would respect people's privacy, such as by consulting with Black communities or Indigenous communities?
Yes, so I do understand that, but first of all, it is not possible for the minister to collect data and not publish it. So that is the problem essentially, is that if the Minister of Health do collect data, it will automatically be published. So that is the main problem. It's essentially, it's going to be published out for anyone. And people with malicious intent, like such as polarized newspaper, can use it basically to create unwanted stigmatization or marginalization of a certain community. So that's the problem. So in my opinion, there's no really way to for the Minister of Health not to publish such data, as it is public information as per paragraph 5 of William versus Canada. So based on the 3 previous examples, it is possible to foresee the same consequences on the Black community, such as their marginalization among other communities. So the previous 3 examples also clearly demonstrate that there is a deterioration of physical, psychological, and emotional health of the concerned communities. Do we really want to reproduce these atrocities again in 2021? It is important to focus on other issues than collecting data in a vulnerable time like the global pandemic. So to summarize everything, the collection of disaggregated race data would breach privacy rights because the data will not remain strictly in the hands of the health minister. In fact, since it is public information as per paragraph 5 of William versus Canada, the data will be diffused by the health minister, which also means that private companies, again, could utilize that information however they want. So this data could be used by private corporations with malicious intent, again, to generate stigmatization, marginalization, or prejudice against a certain group. So for all the above mentioned reasons, our client, the Minister of Health, respectfully seeks order that first, the appeal be dismissed. Secondly, that this honorable court confirms that our client did not infringe any rights guaranteed by Section 7 and Section 15 of the Charters of Rights and Freedom. Thirdly, that this court maintains the Supreme Court Canada's decision. And fourthly, that the appellant assumes all cost. Thank you so much.
Thank you.
Thank you.
I have a question. How do you reconcile your argumentation that collecting data does not increase the risk of being infected by the virus? And at the same time, you say the vaccine will decrease the risk. But if you don't collect the data, how are you going to, or your client is going to effectively use strategy in order to make the vaccine accessible to the group with the part of the population which is severely affected? It's for either one of the council.
Great question, Justice Dortelis. And just to make it clear, we said that not collecting data won't increase the risk of death and not the risk to be affected by the virus. Because obviously, we living in Canada are all susceptible to be affected by the virus because of circumstances. And yeah, it is true that it is by having data and that we can have a vaccine. But even for the vaccine, we said that the vaccine can be a protection against the virus. And we said that data are not strictly protection against the virus, because the thing is, what are we doing with those data? And are those data really efficient to help us to protect? the communities. This is the way we will manage this data. And we cannot assume that as soon as we have data, we have a prediction against the risk of death for the Black community. This is what we want to mean. And also the purpose of the Minister of Health is to protect the health of all Canadians, people, and not the health of communities only, or of the health of specific community. So if we have data, it should be for everyone and not for a specific group.
How about the social context? It is already known that the Black community is largely affected by the virus. It is, even without data, it is, the context is already known. So why your client is not willing to go one step further in order to be very effective in fighting the virus, to get the real picture, a more accurate picture of the situation, in order to, when the vaccine is available, to go to target the segment of the population, namely the Black community, which is severely affected.
Again, it's the good intervention. What I want to say is that the collection of data can have benefits on finding a great vaccine for communities. It is true, perhaps it may be like this. But again, why our client did not collect those data is because to us, there is no obligation under the charter to do it so, and neither under the law. So as we said, this is an omission. This is not on the basis of and political action, or on the basis, under the basis of a law or a regulation. This is not an omission because we do not have that obligation. We do not have that duty to collect disaggregated race-based data. But again, perhaps there is a benefit, but this is not an obligation for us.
And my last question, how do you conciliate your approach for not collecting data with Eldridge, the decision, the ruling of Eldridge pleaded by your colleagues? Eldridge is the decision of the Supreme Court where a woman was deaf, was not provided translation services because no data was collected to know how many, what is the situation, how many people who are affected, or many deaf people who don't have access to such services. Therefore, there were no data collected, and no plan was made to provide such services. How do you reconcile your position with the decision of the Supreme Court, which clearly stated there were some discrimination? There were some infringement of Section 15.
Yeah, again, good question. And to answer to what you are asking to us, it is true that in Eldridge case, no data has been collected, and this, but can we rarely relate the death of that person to the non-collection of data. Like, since when it has been scientifically really established that all the data that we have collect guarantees protection or guarantees to not be exposed to a risk of death. So again, about our case, you are talking about the right to equality. As I said, it's a right to equality is for every community. So is there a really right to equality if we collect data for only Black community? Because it is not on, as you said, Black community is affected by the virus, but it is not only Black community, all the community. So this wouldn't be a discrimination if we only collect data for Black community.
But when in the social context, it is already known that the Black community is severely affected, wouldn't your client don't, according to your position, don't have the obligation to go and find out the exact extent, of the problem. In order, when a solution is found, like when the vaccine came, were to take an approach in order to make sure the section of the population which is most affected get either priority to get the vaccine or get facilitation for the to obtain the vaccine, to send the vaccine to those communities in order to make a plant make it because the rest of the community is not as much as affected. So where is equality if a segment of the population is severely affected and no step is taken in order to make sure that the situation is addressed? Because if it is not addressed, that segment of the population is going to continue to be more affected, and the death rate is going to be increased. I understand when your brief was prepared, you were not aware of the context now. Now the vaccine has arrived, and in the States, the Black population which are most affected, so far, they don't have their share of the vaccine. And I believe that the same could be here in Canada. So by not collecting data is not a way to turn a blind eye and say, we don't know, so we don't know the exact figures, so therefore we treat everybody equal, and then a segment of the population which is not as severely affected get their first share of the vaccine, and the rest of the people who are most severely affected don't get there. Is that equality under Section 50?
So essentially, just to take over a bit, essentially, there is other private companies that do research on these matters, and the government can work with those private companies for further but there's no obligation for the government or our client minister of health to do so. Like I mentioned, collecting such data can cause actually further problems such as stigmatization, marginalization, and discrimination of certain communities. The examples I've given, essentially, they clearly show that collecting data causes a lot of harm actually. And newspapers or political channels, they amplify this and basically put their grain of salt on it and make it sound like a certain community is at fault. And so basically, from my perspective and our client's perspective, there's no obligation for the government to do so, and it will just cause further harm to the community instead of resolving the issue, which also like other third-party companies do a lot of research on this matter. So I mean, for the government itself, there's no obligation to do so.
Thank you.
Thank you.
So there is no further question.
I have no further questions. I believe the next step is the appellant's reply if they have one.
We do have a reply. I will take a little bit and I will give my co-counsel the rest. And I will first speak about the issue that the respondent raised about the fact that there's an omission, but there's no action from the state, and there's no obligation upon the minister. We actually beg to differ. We think there is an obligation on the minister to collect data from a legal standpoint. Right now, I will quote Justice Arbor in the case of Gosselin, page 442, in which he speaks about the importance of having a positive obligation under Section 7. Justice Arbor says that a requirement of positive state interference is not implicit in the use of the phrase principles of fundamental justice or the concept of deprivation in Section 7. The concept of deprivation is sufficiently broad to embrace withholdings that have the effect of erecting barriers in the way of attainment of some object. The context in which Section 7 is found within the charters favors a conclusion that it can impose on the state a positive duty to act. This positive duty to act, when we know empirically that the Black communities have higher rates of infections and mortality, and that this needs to be addressed, there is a duty on the government to protect. We also can see this duty in the Canada Health Act. Section 3 of Canada Health Act says that it's hereby declared that the primary objective of Canadian healthcare policy is to protect, promote, and restore the physical and mental well-being of residents of Canada, and to facilitate a reasonable access to health services without financial or other barriers. So, like the legal scholar Emmett McFarlane, we can see a functional, like government inaction will be functionally equivalent to the harm associated with restrictions or prohibitions. This is in terms of the idea that there's no obligation on the minister. In terms of the issue that the respondent raised about privacy and stigmatization, in our factum, we conceded that there could be a negative consequences of collecting data, but when one looks objectively, the benefits of collecting data outweigh the problems that is associated with it, because having negative effects as an argument does not invalidate the whole idea of collecting data. Negative side effects of collecting data can be remedied and was remedied. If we look at Ontario, when they enacted the Anti-Racism Act, they included something called the Anti-Racism Data Standards, which basically includes privacy protections. They do privacy assessment of the data and how it can be diffused within the government. So we have remedies. Another remedies talked about many critical race theorists. For example, a critical race theorist, Uso Bempa, talked about the importance of engaging the people of color communities so they can look at as leaders who inform the use of and ownership of racial and ethnic data. So this is a political response that we should consult Indigenous people when information needs to be collected. So I am concluding here that remedies are easy to find for the issue of privacy and social stigmatizations, but remedies are difficult to find when we don't have data. And it's empirically proven that when we don't have data, we have higher infection rates, higher mortality in government, in racialized minorities neighborhoods, and the issue is not remedied because democracy works with numbers. And when we don't have numbers, we can't draw policies based on evidence-based policies. So this is our response. I will leave the rest to Olivia to continue.
Thank you to my co-counsel, Tarek, once again. Based off of the argumentation of Section 15 of the respondents, they argue that being affected by COVID-19 is not simply due to the color of a person's skin, rather it's due to being exposed to the virus itself, and that all people are affected by COVID-19 regardless of race. The argument seems to ignore the existence of vulnerable people within our community, which has already been disproven, given that the government is collecting data based off of age as well as gender, but not on race. So their interpretation of Section 15 also seems to interpret the Section 15 of the Charter through the lens of formal equality rather than substantive equality. The factum as well as the pleadings of the respondents seem to heavily rely on the case of Law v. Canada. So I like to quote paragraph 25 of that case, where the court states that equality does not necessarily result from identical treatment. Differential treatment in a substantive sense can be brought about by either formal legislative decision or and I emphasize a failure to take account the underlying differences between individuals and society. Members of marginalized communities are subject to discrimination that disproportionately affect them and impact them. And turning a blind eye is subjecting these members of these communities to additional harm. With that, I'd like to conclude our rebuttal subject to any questions. Thank you so much.
Thank you. I have no further questions.
Thank you. I have no further questions either.
So I believe that we are going to have some time to deliberate, the judges.
Yes.
About 10 minutes. Is it?
Yes.
Do we have to go to another room, or we stay here and we?
So I think we are the ones that are going to have to leave you, your honors alone, so that you can deliberate for about 10 minutes. But first, I'd like to say some closing remarks. I'd like to thank you all for attending the first round of the 2020